SJC-12879, Commonwealth v. Ervin, Feliz.
Mr. Levin.
Thank you, Your Honor. May it please the court, Patrick Levin on behalf of Ervin Feliz. Our law has few principles as fundamental as the requirement that a law enforcement officer have a specific reason for conducting a search of an individual. In fact, commitment to that principle was one of the driving forces behind the American Revolution itself. This court has accordingly maintained individualized suspicion for searches of the people of Massachusetts as an essential building block of our rights under Article 14. Although probationers' expectations of privacy are reduced, they are not altogether forfeited. For more than 30 years, this court has held that the proper balance between the goals of probation and the probationer's expectation of privacy is to permit searches on a lesser showing than is required for other searches of others. But this court has consistently maintained the bedrock principle of requiring some specific reason prior to a search. That principle was reaffirmed just 4 years ago in Commonwealth versus Moore, where this court emphasized that individualized suspicion remains an important safeguard against unfettered law enforcement authority, even for parolees who maintain less of an expectation of privacy than probationers. The condition at issue in this case flaunts that bedrock principle and permits just the unfettered law enforcement authority that Article 14 forbids. It authorizes Mr. Feliz's probation officer to search any part of every electronic device he owns, whenever and however often he chooses, for any reason or for no reason at all. In today's world, this is the equivalent of a founding era officer being authorized to search at his leisure through all of a person's diaries, written correspondence, and financial records. And it also will open up types of information that no founding era officer could have obtained, potentially including historical location data, medical information, and the very contents of the probationer's mind in the form of internet history and search queries. The analogy to the reviled general warrant is nearly inescapable. In Commonwealth versus LaFrance, this court held that suspicionless searches of a probationer are not permissible and remanded for revision of the offending condition to authorize a search only on reasonable suspicion. This court should now follow that binding precedent.
Mr. Levin, I want to interrupt you here to ask you a few questions, please.
Yes, Your Honor.
Now, you notice that the LaFrance line of cases is based on searches of the home, which are always accorded a special role in our search and seizure analysis. So that's number one. Number two, you rely a lot on Riley. But in Riley, the issue wasn't just the search was intrusive, which of course it was. It was that the government failed to demonstrate how the search of the phone was sufficiently tethered to the purported justifications for the search, which are officer safety and evidence preservation. So even if we agree that the searches at issue here are intrusive, aren't they more tailored to the underlying child porn offenses?
Your Honor, so there's two questions there. First, I don't agree that the LaFrance line of cases is limited to the home. The condition at issue—
Have you got any cases that are not? Have you got any cases that are not limited to the home?
LaFrance was not limited to the home. The condition in LaFrance authorized the search of the probationer, her possessions, and her surroundings.
Herself and her surroundings.
Yes, and her possessions.
Herself and her home.
Herself, her possessions, and any place where she may be. That was the condition in LaFrance. And this court said that that condition was not permissible, that the reasonable suspicion standard has to apply. And at the end of the LaFrance opinion, the court sets out what a permissible probation condition would look like. And that condition says that the probationer shall be required to submit to searches of herself or her possessions or any place where she may be upon reasonable suspicion, and with or without a warrant, depending on the requirements of the law. So I don't agree that the case is limited to home searches. Its language is not so limited. It specifically says reasonable suspicion is required for a search of a probationer or her home. As to the second question.
Well, okay, here though, there's no suggestion that he was going to be searched, right? It was a question of whether or not his computers were going to be searched, his computers and his cell phones.
Yes, Your Honor, that's correct. The condition here is as to his possessions, specifically any electronic device that he owns.
Yep. So you don't think that was more tailored? to the underlying child porn offenses that he clearly committed by virtue of his computer and by virtue of his cell phone?
Your Honor, it's somewhat more tailored than the LaFrance condition, but I don't believe it's more tailored than the condition at issue in Commonwealth versus Waller. Waller is a case where the defendant was convicted of animal cruelty, and one of her probation conditions forbid her from owning pets during the probationary term. And the offending condition permitted the MSPCA, in conjunction with the probation office, to search her home and her yard in order to enforce that condition. That condition is tailored to the offense, and I would say is
But also
reasonably
it's limited
related.
to the home. It's in her home. It has to do with her home, doesn't it?
Yes, Your Honor, it does. But Riley specifically says that a search of a cell phone will reveal more potentially than the most exhaustive search of a probationer's home. When it comes to the privacy issues at stake, a cell phone search is on par with a home search.
Justice Cipher has a question.
Yes, I do. Similar to the animal cruelty case, could the judge have not, or probation have not, ordered that the defendant not be permitted to possess electronic devices?
A similar condition to that was imposed in this case, forbidding him to use the internet or internet-connected devices except for work purposes. And that condition is not at issue in this appeal.
Can I ask you, Mr. Levin, about Feliz 1?
Yes, Your Honor.
And whether we should use the balancing test that we set forth in that case, where we balance the extent of that search advances the Commonwealth's interest against a privacy intrusion on the probationer. Is that before us? That's the standard we should look at, right?
Feliz 1, I think the GPS condition is a bit sui generis. It's a very unusual condition where the imposition of the condition itself is a search because you have to attach the GPS device to the probationer's person. And the physical attachment itself constitutes a search. And then the search obviously is ongoing throughout the probationary term.
Right, but Grady tells us it's a search. I just found it odd that you didn't really address the balancing test in Feliz 1, and you relied more on LaFrance.
Your Honor, if in Feliz 1, this court specifically said that as to searches that as to conditions that authorize individual searches of a probationer, LaFrance governs and reasonable suspicion is required. That was still the law in Feliz 1, so I don't think that a different test, I don't think that case calls for a different test here.
Can you walk me through the balancing test in Feliz 1?
In Feliz 1, the balancing that this court did related to the imposition on the probationer's privacy as compared with the government's interests.
Okay. And where does that stack up against your case?
Well, Your Honor, I think that the answer to that is that the imposition on Mr. Feliz's privacy here is enormous and totally untethered from any guidance to the probation officer. So the absolute discretion granted to the probation officer to search any device whenever and however he wants to, without any guidance whatsoever, is totally at odds, even with this court's administrative search and special needs type cases.
Right. And I don't think there's an argument this is special needs, because it would be a short argument if we just decided that all these were special needs. But as
Your Honor,
no, but I'm agreeing with you, Mr. Levin. Give me a chance to agree with you. What I'm saying, there's no argument with that because we keep that doctrine appropriately narrow. What I'm asking you on the governmental interest is it's basically deterrence in this case, realistically, that
I think that's right.
If someone has been convicted of this behavior, which implies some compulsiveness to it, that the person should know, if you get a cell phone, we're going to be watching, so don't visit those sites you shouldn't be going to, correct?
Yeah, I agree that deterrence is the primary interest served by the condition.
Okay.
But I guess just as to the government's interest, and Whether it would be adequately served by the reasonable suspicion standard, I would suggest that it would. I don't know if Justice Kapker, if you want to.
I thought we've moved away in this context from reasonable suspicion to a reasonable relation, haven't we? That's what.
No, Your Honor.
Feliz doesn't use the word reasonable suspicion all the time, right? It talks about a reasonable relationship.
Your Honor, the reasonable relationship test is a due process test that is sort of, it's not on point here. For example, say Mr. Feliz had been ordered not to eat hamburgers during his probationary term. That would violate due process because it's not reasonably related to the goals of probation. But it would present no Article 14 or any other problem as to his other fundamental rights.
But I thought Feliz said the search has to be reasonable, and in order to be reasonable, it laid out the balancing test.
Your Honor, Feliz says individual searches conducted by probation officers are required to be supported by reasonable suspicion of wrongdoing. Feliz specifically cites to LaFrance and preserves its holding. It's, I believe it's footnote 19 in the Feliz opinion.
I'll let Justice Gaziano push back on that. Can I ask you one other question?
Yes, Your Honor.
What could you do here that was narrower given the concern about his looking at child pornography besides just giving up, under your view? What could be narrower to do?
Your Honor, the narrower condition is a condition authorizing searches of his digital devices on reasonable suspicion, which reasonable suspicion could develop in any number of ways, including conversations with the probationer or his associates, information from sex offender therapy groups, independent law enforcement activity, or as occurred in the underlying case here, information coming from websites or file sharing programs or internet service providers. But to step back a little bit on that specific point, infallible enforcement of the probation conditions is never possible in the absence of a total Big Brother style surveillance.
I'm confused though. So we have a drug offense and we have drug testing. Do we only get to do the drug testing if there's a reasonable suspicion that they're using again, or do we just get to do it as a deterrent because there's a reasonable relationship between the condition and the offense?
Your Honor, this court has never conducted an Article 14 analysis of a drug testing condition, but my sense is that the privacy invasion imposed by that condition is sufficiently minimal as to fall under the special needs type of cases. And you can see that from cases like Landry versus Attorney General and the O'Connor case that authorizes drug testing police cadets, that there is not a significant invasion of privacy at stake as it applies to the drug testing condition.
What about an Eldred?
I'm sorry, Your Honor.
What about an Eldred?
Eldred was not an Article 14 case. That's an Article 26 case.
Justice Lowy, and then Justice
Yes.
Seifert.
Thank you. Mr. Levin, you point out it depends to some extent on the level of the intrusion. So
Yes.
maybe you're right in this case, maybe you're wrong in this case, but we've never had this case because LaFrance is a search in the home. Waller's a search in the home. You may win, but we don't have anything on point.
Your Honor, I disagree. For more than 30 years, LaFrance's holding has been reasonable suspicion is the baseline requirement for a probation officer to search a probationer.
Probation officers constitutionally search probationers in many circumstances. You just mentioned drug screens, which happen every day all across the Commonwealth. And you just answered, I think correctly, the question, well, it depends on the extent of the intrusion. And you can't divorce Waller from its facts. You can't divorce LaFrance from its facts. You can analogize to it and we can figure out whether or not you need reasonable suspicion here, but we don't have this case. We've never had this case before.
Well, Your Honor, then if I disagree, but then in making that analogy, I think the U.S. Supreme Court's decision in Riley is highly salient, where Chief Justice Roberts specifically says a search of a cell phone in the modern world is even more invasive of privacy in many cases than a search of the home.
Yes, but Riley, excuse me.
I think Justice Slifer had a question,
Okay.
and Justice Link, if
And
you
then-
have a follow-up.
Sure. I want to go back to my first question, which was about, can't they just tell him he can't have a cell phone or a computer? You said he can't be on the internet, but what if they just say you cannot have a device? Isn't that a decent probation condition under these circumstances? And then don't worry about searching it. It's not there.
Your Honor, perhaps. That condition may present separate issues under the First Amendment, but I can't speak to that on this record.
Okay.
Any further questions for Mr. Levin? Justice Link?
I have a couple. One, I wanted to observe that Riley involved arrestees rather than probationers. And
That's correct, Your Honor.
And so I think that might have parolees probationers may have a lower expectation of privacy than arrestees, don't you think?
I agree. I'm not claiming that Riley is controlling here.
Okay.
I was responding to Justice Lowy's suggestion that we need to analogize in terms of the degree of intrusion on privacy that's happening.
Now, in Commonwealth versus Ships, there was an appeals court decision in 2020. You're familiar with that?
I
Ships?
am counsel in Ships as well.
Uh-huh. And there, the appeals court said it would be difficult to imagine how the probation department could effectively monitor the defendant's adherence to the condition that he not possess child pornography on his cell phone, absent a condition permitting his unannounced targeted search. You disagree with that, presumably?
I do disagree. I listed a number of possible sources for reasonable suspicion earlier. And the other thing I will say is just that a judicial decision to place a defendant on probation incorporates a judicial finding that the defendant is a good candidate for probation and inclined to obey the orders of the court. A certain degree of trust is a fundamental part of the probation system, and in fact, is an indispensable element of the rehabilitative goal of the probationary system. Simply put, if there's no reason to think that the probationer is not complying with the conditions, then there's no reason to think that the probationer is not complying with the conditions.
Well, then what is the justification ever for doing the drug testing, the random drug tests? Your
Honor, that's not the case you have before you.
I understand what we have before us, but I'm saying to you, I mean, why isn't that, if you're correct on that we should always trust probationers to do the right thing, unless not, then I don't understand the basis for random drug searches at all.
Perhaps there is no such basis, Your Honor, but they present a very different Article 14 question in light of the extent of the privacy intrusion they entail.
Mm-hmm. Okay.
Thank you, Mr. Levin.
Thank you very much, Your Honor.
Ms. Campbell?
Good afternoon, and may it please the court. Kaylin Campbell on behalf of the Commonwealth. We ask you today to uphold the denial of the defendant's motion to revise the terms of his probation, as the term which allowed for the random inspection of his electronic devices was individualized to the defendant and reasonably related to the crime he committed. That's all that's required of a probation condition, even one that allows for a random search under Fourth Amendment in Article 14. To answer a question posed by Justice Gaziano, yes, the test in Feliz 1 should apply, and it's both Feliz 1, the test announced in Feliz 1, and the reasoning and test announced in Eldred that should apply. And I disagree with my brother that Eldred is solely a due process case, because if you look at it, it is indisputably a search, and the court mentions the fact that it's a search under the Fourth Amendment in Article 14. It was a reported question, and they decided to uphold that this probation condition was to be upheld so long as it was reasonably related. And it's important that that reasonably related language applies across the board in probation conditions that you see, not only with the Fourth Amendment, but the First Amendment and other constitutional issues. So it's the reasonably related test that should apply, which makes sense in a Fourth Amendment context anyway, because the touchstone of the Fourth Amendment in Article 14 is reasonableness at its base. And certainly here, it is a reasonable search. Now, you can't divorce this case from the crime itself, and that's so imperative to why this condition should be upheld. As explained by this court in Eldred, the success of probation as a correctional tool at all depends on giving judges wide latitude and flexibility to fashion probation conditions that are tailored to individual defendants, their circumstances, and the circumstances of their crime. Under that framework, a judge is permitted to impose a condition that removes a defendant from a situation that presents a danger and risk of recidivism. And the probation condition here does all these things. It can't be stressed enough that the defendant pleaded guilty to possessing child pornography on an electronic device. He disseminated it using electronic device. He used an electronic device to speak to others about child pornography. Electronic devices are a depository of his crime, they're an instrument of his crime, and they facilitated his crime, a crime that takes place in secret.
Could I ask you a question, Ms. Campbell, please? Isn't the condition 8 broader than the electronic devices? It allows the Department of Probation to inspect and to search at random and without announcement any computer, electronic device, digital media, videotape, photographs, or other item capable of storing photographs, images, or depictions for the purpose of monitoring compliance with his conditions of probation. Are you saying that this only affects electronic devices? It doesn't seem to me that that's the case.
I disagree with that in that a computer is an electronic device. Why it's listed separately?
Yeah, but there's other things. How about photographs, videotapes? Videotapes are not electronic devices, are they?
They're certainly not. And
photographs, images, or depictions.
Well, here I would say an image and depiction and a photograph could also be electronic. So, and the places that they stored.
So you're basically saying to any extent we have to read this as being only limited to electronic devices. We can limit it to the electronic devices.
I don't. You know, if the court wants to say that it's not okay to say that, you know, possession of these physical items, you can't go into his home and search for these physical items, that's fine. You know, I think that there is a difference between a probationer's home and a device that he possesses that is an instrument of the crime that he committed. The Commonwealth is not alleging that they can go into his home or search his bodily person for these items. Our focus is, in this case, on the computer, on the electronic items that have the capability of storing those items.
What about LaFrance and the language in LaFrance that essentially allowed a search on site?
Sure. I think LaFrance can be distinguished in two separate ways. The first is that it's a search of a home, and though the condition
well,
itself.
Not necessarily. If they saw Mr. I'm assuming it was Mr. LaFrance. If they saw Mr. LaFrance on the street corner, he could be searched.
It's actually a female.
It was.
Yes.
Yeah.
And Waller is as well. But if they saw Ms. LaFrance on the street, yes, that probation condition did say that they could search her bodily person. I don't think that there's a difference. That what they actually analyzed in that case was the search of her home, and they talked about the entrance into her home. But I think it's different because even if you were to apply that reasonably related test, she was convicted of burglary and larceny. And there's nothing to show why they would believe that the burglary or items, you know, you could have a tool in your home or in your possession and it wouldn't necessarily be reasonably related to the crime that you committed.
But apart from reasonably related, they use a reasonable suspicion standard, right? So it's not probable cause. It's a lesser search and seizure standard, a search and seizure standard nonetheless.
Absolutely,
so how is that not applicable here?
I'd say it's not applicable here. LaFrance comes before Feliz 1, and in Feliz 1, it undeniably was a search of the defendant's person and then of his data. And the defendant in Feliz 1 asked this court to apply a reasonable suspicion test, and it did not. It adopted the balancing test and just said that it needed to be individualized to the defendant. And really, when you think about that, what the court is looking at is a nexus between the probation condition and the crime and the furthering the goals of probation. And when you look at it that way, it's very different from LaFrance or even Waller, because in those cases, the item or the place that was to be searched wasn't an instrument of the crime and wouldn't necessarily be a depository or used to facilitate the crime that the defendant had pled guilty to. So in that way, it's vastly different and can be factually distinguished from those cases. But those cases both were also decided both before Feliz 1 and before Eldred. Which have not and did not use that reasonable suspicion test. And even more than that, you know, when we're looking at any search and seizure question, it doesn't fall or rise on the level of what articulated test the court applies. It has to do, the touchstone is reasonable. So at its base, the very most basic question that the court should ask is whether this is a reasonable search in relation to all of the circumstances that are present.
May I ask a question?
Mhm.
Yes. Okay. My question is this. Now, don't you think the trial court judge sort of undervalued the degree of intrusiveness here? I mean, he really didn't give much attention to this at all.
I don't, and I think I don't, and I don't for two reasons. The first is that I think he appropriately applied Eldred and recognized that the defendant as a probationer had a lessened expectation of privacy. But more than that, as was spoken about during my brother's argument, it would be entirely permissible for a judge to say that a defendant could not possess one of these electronic devices at all. And I don't think that that should be lost in the analysis.
You think that's worse than being able to search through something that somebody has?
Yes.
I don't think Riley would agree with you. I don't think the Supreme Court and Riley would agree with you. I think that they're saying that the search of a cell phone is very intrusive. But I'm not sure that that's dispositive, however, Ms. Campbell.
I don't believe Riley is dispositive, but I disagree. I think it's more restricted to say you as an individual can never have possession of an electronic device at all. I think if we are to look at the legitimate goals of probation and the wide latitude that judges are given, allowing these searches in this type of crime, and it's important to note that the Commonwealth is limiting its argument to this type of crime, strikes the appropriate balance between giving the defendant ability to access this type of device and protecting the public, protecting the re-victimization of child victims in this case, as opposed to just outright banning his ability to possess or use these items at all.
Well, suppose we disagree with you on this. Suppose we disagree with you on the degree of intrusiveness. But there's still a balancing here to be done. Is there not? What are the government interests here?
So the government interests, I think, are twofold. The first is to prevent recidivism, which is to place a watchful eye on whether the defendant could engage in these type of activities the same way as if you were to order a random drug and alcohol screen. The cell phone, like urine in that case, is a depository of the criminal act, right? It would looking at it randomly would show evidence as to compliance of the probation condition. And for the same reasons you would allow the random drug and alcohol screen as it relates to urine, that same analysis and that same justification, as explained better than I am right now, but explained in Eldred, applies here. And so for that reason, I think that it furthers that goal. Yes, Justice Eifert.
Yeah, my question is, if we permitted this and the limitation was to look for child pornography or make sure you're not using it, and they're checking the cell phone looking for that, but they see evidence of another kind of crime, that would be admissible evidence, wouldn't it, under some kind of plain view doctrine? You can use it for a new crime.
Yes, and you know, my brother raised in his argument, I think I didn't read his brief to be arguing that the problem with this probation condition was that it gave too much discretion to the probation officer. I read it more that these type of conditions could never exist, regardless of how limited that they were. But yes, Justice Lowy.
So am I remembering correctly, the context of this decision was a motion of the probationer to remove the condition?
Yes.
Okay, so we don't have in this case, well, what if the probationer showed up and was given consent to come in the home and then took the computer, or what if he was walking down the street and he had his phone out and the police officer went up to him, or the probation officer, and took the phone? We just don't have that case.
We don't.
So this is a little bit difficult to figure out where this where this line is. Mr. Levin said it depends on the extent of the intrusion. I agree with that. And what would your position be if the probation officers went into the house without reasonable articulable suspicion and grabbed the computer or the phone and started to go through it? And something was found. Would that constitute a seizure and require suppression?
Entering the home, yes, because the home indisputably has different constitutional protections under search and seizure law.
And as far as if we had this case, we don't have it here since it was a motion to remove the condition. So it seems like the focus would be how the condition fits the crime. But if we had the case where the probation is walking down the street, the police come and they grab the phone, well, that may well be too much of an intrusion, but that again is not this case.
Sure, and if you look at the probation term itself, condition 8, it contemplates, I think it says the probation department conducting the search. So I don't think it would fall into the factual scenario that, you know, police officers under the guise of doing something else just come and grab his phone and have the ability to search it. I think it's contemplated that it would be a probation officer to monitor for compliance with the terms of probation.
All right. So it's important to try and develop where this line is. We know you can't go into the home and grab the computer. You agree with that?
Yes.
Mr. Levin hasn't taken a firm position, but he recognizes that the random screen condition might be a difficult case. And there's somewhere perhaps in the middle. And I wonder if a case where a motion to remove a probation condition is the right case to sort of flesh out the doctrinal approach to that middle.
I don't see why it wouldn't be, where the reasons why it's challenged by the defendant are that you could never have such a condition. And I think saying you could have a condition so long as it's narrowly tailored, individualized, and reasonably related to the legitimate goals of probation. I think so long as it reaches all those things, then that's the question that should be answered and it would be okay. Now, Justice Lowy, it appears that your question is more about how this is actually executed, which I think presents a different legal question and a different legal analysis. But
that's my point.
Yes, but the actual analysis as to whether, you know, academically this could exist, I think the answer to that is yes, and I think that this case is the right case in which to answer that. Yes, Judge Lane.
Just like
Isn't it? I mean, the defendant's probation, he's no longer on probation. He's been released from probation, right? This
No,
defendant.
he's still on probation. He was released from condition 9.
I misunderstood that.
I believe he's still on probation until April of 2021. I'm not entirely clear.
This case is not moot.
I don't believe so.
All right, okay.
And just maybe finally, Ms. Campbell, Justice Link asked you for the governmental interest. You got to number 1, and you said there were 2. You didn't give us number 2. Number 1 had to do with deterrence. What's number 2?
To prevent recidivism, which is a judge can lawfully and permissively sort of take away the temptation for the defendant to commit the crime, say that he cannot be in a position so that he could commit the crime.
Is this similar? So I mean, we have these conditions in drug and alcohol and OUI cases. It seems to me that we have these conditions that involve compulsive behavior that we want to deter. Okay. Any further questions for Ms. Campbell?
I will rest on my brief. Thank you.
All right, thank you, counsel. Thank you, Mr. Levin.
Thank you, Your Honor.